Then Title IX passes, and a government official comes around and says to this colleges, you want money for your physics labs and all the other things you get it for. Then you have to create an athletic program for girls. And the recipient says, I am being coerced. There's no way in the world I can give up all the funds to run all these labs that we have. I can't give it up. So I'm being coerced to accept this program that I don't want. Why doesn't your theory, if your theory is any good, why doesn't it work any time someone receives something that's too good to give up?
Well, Justice Ginsburg, there's two reasons that might be different. One is this whole line of coercion only is only relevant really when Congress tries to do something through the spending power it couldn't do directly. So if Congress tried to impose Title IX directly, I guess the question for this Court would be whether or not Section 5 of the 14th Amendment allowed Congress to do that. I imagine you might think that it did, and I imagine some of your colleagues might take issue with that, but that's the nature of the question. So one way around that would be if Congress could do it directly, you don't even have to ask whether there's something special about the spending power. That's how this Court resolved, for example, the Fair case about funding to colleges.
I'm trying to understand your coercion theory. I know that there are cases of ours that have said there's a line between pressure and coercion, but we have never had in the history of this country or the Court any federal program struck down because it was so good that it becomes coercive to be in it.
Well, Justice Ginsburg, I'm going to just say the second thing about my answer to your prior question, which is just I also think that, it may be that spending on certain private universities is something, again, that Congress can do, and it doesn't matter whether it's coercion. But when they're trying to get the states to expand their Medicaid programs, that's something.
Let's take public colleges.
Okay. Then there may be some limits on that. I mean, but again, I'm not sure even in that context there might not be some things Congress can do. It's a separate question. But once we take the premise, which I don't think there's a disagreement here, that Congress could not simply, as a matter of direct legislation under the Commerce Power or something, say, states, you must expand your Medicaid programs. If we take that as a given, then I think we have to ask the question of whether or not it's coercive. Now, in your second question, you asked, well, where's the case that says that we've crossed that line? And this is that case. I would respectfully.
And it doesn't it apply as well to the 1980 extension to children 0 to 6 years old, 1990 requiring the extension for children up to 18. All those prior extensions to me seem just as big in amount, just about as big in the number of people coming on the rolls, and they all are governed by precisely the same statute that you're complaining of here, which has been in the law since 1965.
Justice Breyer, I don't think that our position here would necessarily extend to, say, the 1984 amendments, and let me tell you why. I'm not saying that absolutely that's guaranteed that's not coercive, but here's reasons why they're different. The one major difference is the size of the program. I mean, the expansion of Medicaid since 1984 is really breathtaking. Medicaid circa 1984, the federal spending to the states was a shade over $21 billion. Right now, it's $250 billion, and that's before the expansion under this statute.
Well, if you are right, Mr. Clement, doesn't that mean that Medicaid is unconstitutional now?
Not necessarily, Justice Kagan, and again, it's because we're not here with a one-trick pony. And one of the factors, we point you to three factors that make this statute uniquely coercive. One of them is the sheer size of this program. And, if you want to gauge on the size of this program, the best place to look is the government's own number. Footnote 6, page 10
So
of your
when does
brief.
the program become too big? At what, give me a dollar number.
$3.3 trillion over the next 10 years. That
All
is
right, so I'll tell you this number, which I did look up, that the amount approximately, if you look into it, as a percentage of GDP, it's big. But it was, before this, somewhere about 2-point-something% fairly low of GDP. It'll go up to something a little bit over 3% of GDP. And now go look at the comparable numbers, which I did look at, with the expansion that we're talking about before, the expansion from 0 to 18 or even from 0 to 6. And while you can argue those numbers, it's pretty hard to argue that they aren't roughly comparable as a percentage of the prior program or as a percentage of GDP. If I'm right on those numbers, or even roughly right, I don't guarantee them, Then would you have to say, well, indeed, Medicaid has been unconstitutional since 1964. And if not, why not?
The answer is no, and that's because we're here saying there are three things that make the statute uniquely.
What are your second and third? I'm on pins and needles to hear
exactly. Well, one is the sheer size. Two is the fact that this statute uniquely is tied to an individual mandate, which is decidedly non-voluntary. And three is the fact that they've leveraged the prior participation in the program, notwithstanding that they've broken this out as a separately segregated fund going forward, which is not true.
So on the third, suppose you have the current program and Congress wakes up tomorrow and says, we think that there's too much fraud and abuse in the program, and we're going to put some new conditions on how the states use this money so we can prevent fraud and abuse, and we're going to tie it to everything that's been there initially. Unconstitutional?
No, I think that is constitutional because I think that's something that Congress could do directly. It wouldn't have to limit that to the spending program. I think 18 U.S.C. 666 is a statute, it's in the criminal code. It may be tied to spending, but I think that's a provision that I don't think it's constitutional, at least called into question.
I guess I don't get the idea. I mean, Congress can legislate fraud and abuse restrictions in Medicaid, and Congress can legislate coverage expansions in Medicaid.
Well, Justice Kagan, I think there's a difference. But if I'm wrong about that, and the consequence is that Congress has to break Medicaid down into remotely manageable pieces, as opposed to $3.3 trillion over 10 years before the expansion, I don't think that would be the end of the world. But I really would ask you to focus on specifically what's going on here, which is they take these newly eligible people, and that's a massive change in the way the program works. These are people who are healthy, childless adults who are not covered in many states. They say, okay, we're going to make you cover those. We're going to have a separate program for how you get reimbursed for that. You get reimbursed differently from all the previously eligible individuals. But if you don't take our money, we're going to take away your participation in the program for the visually impaired and the disabled, if I may reserve the balance of my time.
Well, I'm not sure my colleagues have exhausted their questions. So,
my greatest fear, Mr. Clement, with your argument is the following. The bigger the problem, the more resources it needs. We're going to tie the hands of the federal government in choosing how to structure a cooperative relationship with the states. We're going to say to the federal government, the bigger the problem, the less your powers are. Because once you give that much money, you can't structure the program the way you want. It's our money, federal government. We're going to have to run the program ourselves to protect all our interests. I don't see where to draw that line. Well, the uninsured are a problem for states only because they too politically, just like the federal government, can't let the poor die. And so to the extent they don't want to do that, it's because they feel accountable to their citizenry. And so if they want to do it their way, they have to spend money to do it their way. If they don't want to do it the federal way. So I just don't understand the logic of saying states, you're not entitled to our money, but once you start taking it, the more you take, the more power you have.
Well, Justice Sotomayor, a couple of points. One is I actually think that sort of misdescribes what happened with Medicaid. I mean, states were, as you suggest, providing for the poor and the visually impaired and the disabled even before Medicaid came along. Then all of a sudden the federal government says, look, we'd like to help you with that, and we're going to give you money voluntarily. And then over time, they give more money with more conditions, and now they decide they're going to totally expand the program, and they say that you have to give up even your prior program where we first came in and offered you cooperation. We're now going to say you have to give that up if you don't take our new conditions. Secondarily, I do think that our principle is not that when you get past a certain level, it automatically becomes coercive per se. But I do think when you get a program and you're basically telling states that, look, we're going to take away $3.3 trillion over the next 10 years, that at that point it's okay to insist that Congress be a little more careful that it not be so aggressively coercive as it was in this statute. And I would simply say that we're not here to tell you that this is going to be an area where it's going to be very easy to draw the line. We're just telling you that it's exceptionally important to draw that line. And this is a case where it ought to be easy to establish a beachhead, say that coercion matters, say there's 3 factors of this particular statute that make it as obviously coercive as any piece of legislation that you've ever seen, and then you will have effectively instructed Congress that there are limits, and you have laid down some administrable rules.
Mr. Clement, the Chief has said, I can ask this.
He doesn't always check for
As I recall your theory, it is that to determine whether something is coercive, you look to only one side, how much you're threatened with losing or offered to receive, and the other side doesn't matter. I don't think that's realistic. I mean, I think, you know, the old Jack Benny thing, your money or your life, and, you know, he says, I'm thinking. It's funny because it's no choice. You know, your life, again, is just money. It's an easy choice, no coercion, right? I mean, right? Now, whereas if the choice were your life or your wife's, that's a lot harder. Now, is it coercive in both situations?
Well, yes, it is.
Really?
I mean,
it's a tough choice in the later.
I thought you were going to say this statute is your money and your life.
Yeah, well, and it is, but I mean,
Which way?
I might have missed something, but both of those seem to be the
No.
coercion.
To say when you say you're coerced, it means you've been given an offer you can't refuse. Okay, you can't refuse your money or your life, but your life or your wife's, I could refuse that one.
Let's leave the wife
Mr.
out.
Clement, he's not going home tonight.
Let's leave the wife out.
I was going to say, Mrs. Clement.
No, I'm talking about my life. I'd say, take mine, you know.
I wouldn't do that either.
Let me use that example. Forget about it.
It's enough frivolity for a while. But I want to make sure I understand where the meaningfulness of the choice is taken away. Is it the amount that's being offered, that it's just so much money, of course you can't turn it down? Or is it the amount that's going to be taken away if you don't take what they're offering?
It's both, Your Honor, and I think there really is, 3 strings in this bow. I mean, one is the sheer amount of money here makes it very, very difficult to refuse, because it's not money that, has come from some, China or from the export tariffs like in the old day. It's come from the taxpayers. So that's part of it. The fact that they're being asked to give up their continuing participation in a program that they've been participating in for 45 years as a condition to accept the new program, we think that's the second thing that's great.
Why isn't that a consequence of how willing they have been since the New Deal to take the federal government's money? And it seems to me that they have compromised their status as independent sovereigns because they are so dependent on what the federal government has done. They should not be surprised that the federal government, having attached they tied the strings, they shouldn't be surprised that the federal government isn't going to start pulling them.
With all due respect, Mr. Chief Justice, I don't think we can say that, the states have gotten pretty dependent, so let's call this whole federalism thing off. And I just think it's too important because, again, the consequence, if you think about it, if the consequence of saying that we're not going to police the coercion line here shouldn't be that, it's just too hard, so we'll give the federal Congress unlimited spending power. The consequence ought to be, if you really can't police this line, then you should go back and reconsider your cases that say that Congress can spend money on things that it can't do directly. And we're not asking you to go that far. We're simply saying that, look, your spending power cases absolutely depend on there being a line between coercion and voluntary action.
I don't understand your first answer to Justice Kagan. You don't see there being a difference between the federal government saying, we want to take care of the poor. States, if you do this, we'll pay 100% of your administrative costs. And you said that could be coercion. All right? Doesn't the amount of burden that the state undertakes to meet the federal obligation count in this equation at all?
It certainly can, Justice Sotomayor. I didn't mean to suggest, in answering Justice Kagan's question, that my case was no better than that hypothetical. I mean, but it's in the nature of things that I do think the amount of the money, even considered alone, does make a difference, and it's precisely because it has an effect on their ability to raise revenue from their own citizens. So it's not just free money that they're turning down if they want to. It really is.
If we go back to that era of matching what a state pays to what a state gets, Florida loses. Its citizens pay out much less than what they get back in federal subsidies of all kinds. So you can't really be making the argument that that Florida can't ask for more than it gives, because it's really giving less than it receives.
Well, then
I don't really want to go back to that point, do you?
Well, then I'll make that argument on behalf of Texas. But it's not what my argument depends on, and that's the critical thing. It's one aspect of what makes this statute uniquely coercive. And I really think if you ask the question, what explains the idea that if you don't take this new money, you're going to lose all your money under what you've been doing for 45 years to help out the visually impaired and the disabled? Nobody in Congress wants the states to stop doing that. They're just doing it, and it's purely coercive to condition the money. It's leverage, pure and simple.
If the inevitable consequence of your position was that the federal government could just do this on its own, the federal government could have Medicaid, Medicare, and these insurance regulations, assume that's true, then how are the interests of federalism concerned? How is the interest of federalism concerned if in Florida or Texas or some of the other objecting states there are huge federal bureaucracies doing what this bill allows the state bureaucracies to do? I know you've thought about that. I'd just like your answer.
I have, and I'd like to elaborate, but the one-word answer is accountability. If the federal government decides to spend money through federal instrumentalities and the citizen is hacked off about it, they can bring a federal complaint to a federal official working in a federal agency. And what makes this so pernicious is that the federal government knows that the citizenry is not going to take lightly the idea that there are huge new federal bureaucracies popping up across the country. And so they get the benefit of administering this program through state officials, but then it makes it very confusing for the citizen who doesn't like this. Do they complain to the state official because it's being administered by a state official in a state building?
But Mr. Clement, that is very confusing, because the idea behind cooperative federal-state programs was exactly a federalism idea. It was to give the states the ability to administer those programs. It was to give the states a great deal of flexibility in running those programs, and that's exactly what Medicaid is.
Well, that's exactly what Medicaid was. The question is, what will it be going forward? And I absolutely take your point, Justice Kagan. Cooperative federalism is a beautiful thing. Mandatory federalism has very little to recommend it because it poses exactly the kind of
cooperative federalism does not mean that there are no federal mandates and no federal restrictions involved in a program that uses 90% here, 100% federal money. It means there's flexibility built into the program subject to certain rules that the federal government has about how it wishes its money to be used. It's like giving a gift certificate. If I give you a gift certificate for one store, you can't use it for other stores, but still you can use it for all kinds of different things.
But I absolutely agree that if it's cooperative federalism and the states have choices, then that is perfectly okay. But that's why voluntariness and coercion is so important. Because if you force a state to participate in a federal program, then, as long as it's voluntary, then a state official shouldn't complain if a citizen complains to the state about the way the state's administering a federal program that it volunteered to participate in. But at the point it becomes coercive, then it's not fair to tell the citizen to complain to the state official. They had no choice. But who do they complain to at the federal level? There's nobody there, which would be — I'm not saying it's the best solution to have federal instrumentalities in every state, but it actually is better than what you get when you have mandatory federalism and you lose the accountability that's central to the federalism provisions in the Constitution.
Thank you, Mr. Clement. General Verrilli.
Mr. Chief Justice, and may it please the Court, the Affordable Care Act's Medicaid expansion provisions will provide millions of Americans with the opportunity to have access to essential health care that they cannot now afford. It is an exercise of the spending clause power that complies with all of the limits set forth in this Court's decision in Dole and the states do not contend otherwise. The states are asking this court to do something unprecedented, which is to declare this an impermissibly coercive exercise.
What do you think we meant in those dicta in several prior cases where we've said that the federal government